Hi guys, it's Cindy with Twisted Truth, and how you guys all doing? Wanted to read you something about the Zone of Death, Idaho. Now, Lori Vallow and her brother Alex Cox took J.J. and Tylee to this area, and it's 50 square miles. But it's interesting what it says. Okay, so a law professor from Michigan State University uncovered a constitutional loophole that could let a killer walk free. For hundreds of years, legal experts and criminals alike have been enamored with the perfect crime, a crime that is so well orchestrated that it can be pulled off without a hitch, and the perpetrator can walk free. In Yellowstone National Park, there lies a 50 square mile area of land that, due to a constitutional loophole, exists outside of any kind of formal jurisdiction. The bulk of the park, 91% of it to be specific, lies inside the state of Wyoming. The remaining 9% of the park, northern and western borders, bleed into the neighboring states of Idaho and Montana. However, because the majority of the land is in Wyoming, the entirety of the land is considered a district of Wyoming, and the state is responsible for governing it, including 9% that falls outside the state's borders. The fact that Wyoming has control over small pieces of land in Idaho and Montana may seem like a huge deal, but Michigan State University law professor Brian Kalt noticed a particular stipulation. He says, to fully understand the loophole, you're going to need to brush up on your knowledge of the Constitution. The Sixth Amendment to the Constitution states that for a trial to be held, jurors must reside in both the state and the district in which the crime was committed, meaning that jurors would have to live in the particular block of land that the crime took place. And so the issue is a portion of Yellowstone in the zone of death lies in Idaho and is virtually uninhabited, heavily wooded, with few visitors every year. So, of course, Lori Vallow brings her children there to go camping on September 8th. These are one of the last photos of her daughter, Tylee, 17. And the crazy thing is, the FBI in Idaho today requested the public's help in locating photos of Lori Vallow, her brother, and her two children at the zone of death in Idaho at Yellowstone. Why did they wait so long? I don't understand it. And now they uncovered a letter from Charles Vallow. I think they're going to investigate him too. That's just a hunch. Okay, guys, so anyway, I just thought I'd let you know about this.
So I respectfully disagree with the prosecutor's assertion that Lori will be convicted of these charges. I have represented to the court as I have a duty of candor to the tribunal that Lori will be residing locally. And as I indicated, I'm happy to provide that address to your honor under seal to protect Lori in this case. The prosecutor has gone through a litany of allegations for which she is not facing any sort of criminal charges whatsoever, and not criminal charges in this case. Those should not be considered by the court for purposes of this case and setting bond pursuant to Idaho, the factors listed in Idaho Criminal Rule 46. We would ask that you grant the defendant's request and set bail as requested in this matter.
Thank you, Ms. Alcox. The court has listened carefully to the argument of both the state and the defense. The court has reviewed in detail and in full Rule 46 of the Idaho Criminal Rules. The court has also reviewed the Idaho Bail Act, Title 19, Chapter 29, specifically under 192904. It designates that the court may release a person on his own recognizance or set an amount of bail and may impose any conditions of release. In making these determinations, the court shall consider the following objectives. Number 1, ensuring the appearance of the defendant. Number 2, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Number 3, ensuring the protection of victims and witnesses. And number 4, ensuring public safety. The court has taken all 4 of those factors into consideration, as well as all 10 factors under subsection C under the Idaho Criminal Rules 46. And based upon the argument that I've heard here today, the court is going to reduce bail. I'm going to reduce bail to the amount of $1 million. I recognize all of the factors that have been looked at here. One specific thing that the court notes in setting such a high bail amount is that there is a pending court order, and to my knowledge there has been nothing set forth regarding obedience to that court order pertaining to lining the court out with information on where the 2 children are at the Department of Health and Welfare or at the Rexburg Police Department. So with that, bail will be set at $1 million. If bail is posted, there will also be the following conditions that are ordered. Number 1, there will need to be a waiver of extradition signed from any and all jurisdictions to be brought back here before the court. Number 2, I'm going to require that Ms. Daybell not leave Bonneville, Jefferson, Madison, and Fremont counties. If she were to leave any of those counties while this case is pending without permission or authorization from the court, that would be a violation of the terms of bond and release. I'm also going to order that there be an ankle monitor that is placed on the defendant. That will need to be all lined out before she's eligible to bail out. It will be monitoring 24 hours a day, 7 days a week as to where the defendant is. And then lastly, I'm going to order as a term of any release or bail that the defendant appear for all court appearances, that she maintain contact with her counsel, and that she abide by all the laws of this state, this country, this county, and this city. Mr. Wood, do you have any questions about my ruling regarding the reduction of that bail?
No, Your Honor.
Ms. Elcox.
Just briefly, Your Honor, does the court have a specific form for the waiver of extradition you would like us to use?
I think the jail has one. Does the jail have a form that they have? If you'll communicate with the jail, I think they do have a form. If not, why don't you submit the one after you've gotten approval from Mr. Wood? You can submit that after she signed it, and the court will review to make sure it meets my satisfaction.
Yes, Your Honor. And do you have, would you like us to coordinate setting up the ankle monitor through the jail, or do you have a specific agency you would like us to use? You
can coordinate with the jail and or the sheriff's office. They'll know that information. They may have someone that they usually use. I'm not sure of that. If you have a preference, you could provide that information to them, and if there's an issue, it can be brought before me for my approval. Any other questions?
No, thank you.
I believe that takes care of everything that we're here for today. In a moment, I'm going to leave. When I do that, the audience is going to be asked to rise. I'm going to leave the courtroom. After I leave, I'm instructing everybody to be seated again. There will be the removal of the defendant from the courtroom, and then everybody will be excused row by row pursuant to court personnel here today. With that, we'll be in recess.
All right.
Talk to you later. Love you. Bye.